Code Enforcement Board is called to order.
We're good.
We're good.
You can go now.
Okay. Just looking at our videographer back there, he's making some kind of motions, and I wanted to make sure we're good to go. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Agendas of today's meeting are on the wall at the entrance to chambers. Please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board consists, I'll give you that again, the board considers new business items in 2 parts. First, the violation, and then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak, please rise and be sworn in by the clerk.
Do you swear or affirm to tell the truth throughout your entire testimony? Yes. Thank you.
Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
Motion to approve.
May I have a second?
Second.
All in favor? Aye. All opposed? Motion carries. Next on the agenda are new business items. Under our new business items, 3.1 has been withdrawn, 3.2 has been withdrawn, 3.3 has been withdrawn, 3.4 continued for March is going to continue to May 27th, 3.5 continued for March 25th is going to be continued to May 27th, 3.6 is going to be continued to May 27th. Our first case up to listen to is 3.7, case 74-26. Fine respondents Juan Avella at 2104 Brigadoon Drive in violation of code for clean roof and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on that matter? Inspector, you have the floor.
Good afternoon, Board. Inspector Daniels, case number, Inspector for the City of Clearwater, case number 74-26. This is for address 2104 Brigadoon Drive. It's one violation at this residence for code section 3-1502D.3 for roof maintenance. The notice of violation was sent out at April 18, 2025, with a compliance date of May 21st, 2025. Certified mail was received April 29th, 25. There go the pictures from the initial inspection. Leaves, the gutters are growing trees out of them. This was after the compliance date. This was the front. And then I was out there this morning, and they're still there, and the back is just still growing weeds out of the gutters. Compliance can be met for roof maintenance by maintaining the roof in a clean, mildew-free condition and kept free of trash, loose shingles, debris, and other elements, including grass, weeds, and tarps, as well as anything that is not a permanent part of the building or a functional element of its mechanical or electrical system. So recommendations for the roof maintenance: requesting compliance on or before June 1st, 2026, or a fine of $150 per day per violation if compliance is not met.
Thank you. Board, do you have any questions? Have you spoken with the owner?
No, sir.
Have you attempted to speak with the owner?
Yes.
Okay. No response?
No response.
All right. Any other questions from the board?
No.
May I have a first motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Aye.
All opposed? Motion carries. May I have a second motion, please?
I move to enter an order requiring the respondent to correct the violation. What was the date there, please?
June
June
1st.
June 1st, thank you. Respondent to correct the violations on or before June 1st. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
Sorry?
Second.
All right. All in favor?
Aye.
All opposed? Motion carries.
Thank you.
Thank you. Our next case, 3.8, has been withdrawn. Case 3.9, case 76-26, fine respondents, Belize Enterprises Incorporated at 1004 South Martin Luther King Jr. Avenue, in violation of code for permits and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Inspector Reese, you have the floor.
Okay, good afternoon, Code Board. I'm Inspector Kat Reese, Inspector of the City of Clearwater. This is going to be for 1004 Martin Luther King Jr. South Avenue. This is for case 76-26. And it's going to be for one violation for permits required. This violation is specifically for the permit for the building for the rafters, framing, roof, interior remodel to include electric, plumbing, drywall, subfloor, and removal of window. There were multiple notice of violations that have gone out. The initial one was sent May of 2024, and the last one sent October of 2025. Affidavit of posting was posted on 6/3 of 24. This is going to be on South Martin Luther King, just south of Druid Road. And this was the inspection pictures from the previous inspector who started the case of the work that was being done there. On a later date, PCCLB was contacted the inspector to advise that they were doing work in the interior. So it was a little bit after the initial inspection that they went back out and saw that more work was being done. So this is still on the outside, and this is in the inside. It's just complete remodel. And I have been in contact with the property owner for this property many times. So to elaborate on that, he wants to do a lot with the property, and he keeps hiring contractors to move forward, but then pulls. So as of today, we do have a permit that is requiring more additional information to have an issued permit. It cannot get issued until those revisions are met. And that is why I'm still bringing it here today, because it's not an active permit. And I want to be able to set a date of completion with inspections, because that is the point of the permits, after all. And here's just one of the letters from one of the previous contractors that voided out their contracts for this job, as well as another. This is all the contact I've had with a lot of contractors or engineers, either one. And again, from another contractor, where he's going a different direction. And that's basically what each conversation has been. The plan, they advise me what it is, and then they say, we're we're pulling, or he's going another route. So at this point, the last time I spoke with an architect, he had assured me there would be a permit in, that he's now gone with someone new who has pulled this permit. So compliance can be met by obtaining a permit and completing said permit with final inspections. Requesting compliance by obtaining a permit on or before May 22nd of 2026, and a completion of the permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist. Any questions?
This has been going on how long? About 2 years now?
2 years, yes.
Does the board have any, sorry?
Is that typical? Is it, we just been really,
There's been a lot, COVID, COVID was well past at this point, but I mean, there was a break of inspectors in the department, so it would only be a speculation of mine as to why it's sat, but I did take it on immediately from coming on board, and I have been in contact with the property owner, but he understands, like, yeah, I told him, we got to get something set and completed at this point, and I've worked with him as much as I possibly can.
he starts to get a permit and then pulls out, or doesn't?
Right, so the last, like, if I go back, let me go back here real quick. So the initial permit that was pulled in 2024 was voided out by the contractor, and then again by another contractor. These are void letters, and they have to send those, so that way that takes the liability off the contractor as to why this was not completed.
Is there a stop work order on the
Yes,
property?
this was all based on a stop work order for the work being done without a permit.
But then you keep finding more work is being done even though there's a stop work order on it?
He has stopped now, because I know he has understood that the building needs a whole lot more work than what he thought after speaking to professionals. I don't know if it's a money thing. I don't really want to speak for him.
Yeah.
But we have high hopes here. He's got a permit in, but he's technically in violation until there's an active permit and it is completed.
Okay.
All right, any other questions?
What's the compliance date you're seeking?
I'm sorry?
What's the compliance date you're seeking?
It's going to be 6 months from the date of issuance. So I'm requesting for May 22nd to have an issue permit and 6 months for completion.
I have a question. Based on what you've seen, do you think that permit issuance, this may be a question for the building department if they're familiar with it, if that compliance date is realistic in terms of what they've submitted? I know this has been a long case, and I'm not advocating necessarily giving them more time. I'm just thinking in terms of where they are in the process, and can they actually get a permit issued by then?
Getting a permit issued, they just submitted the plans the other day. So they waited till the last minute to submit those plans. I really couldn't speak on it without reviewing those or having everyone review that. But it is on my discretion that even once the permit is active, if they're having issues getting the permit completed, they at least have the active permit. If I'm seeing that they're having inspections, they're passing or they're working to pass, then, because that's really ultimately what we want, is to make sure everything's up to code. That's the whole point of the permit.
Okay, and you're asking for a compliance date of?
To issue the permit May 22nd.
Gotcha.
I have not heard from the new contractor to really give much more time than that.
Okay, thank you. Any other questions from the board? May I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
May I have a second?
Second.
All in favor?
Aye.
Aye.
All opposed? Motion carries. May I have a second motion, please?
I move to enter in an order requiring the respondent to correct the violations on or before May 22nd, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a
Second.
second? All right, thank you.
Yes.
All in favor?
Aye.
All opposed? The motion carries. Thank you, Inspector. Next case is 3.10 on our agenda. Case 77-26, fine respondents Malaise Enterprises Incorporated at 1004 South Martin Luther King Avenue in violation of code for permits, and issue an order with a compliance deadline and fine if compliance is not met. Is this not the same
Yes.
address?
It is the same address, so this will be a bit quicker because it's going to be basically the same talk.
Well, I believe, thank you.
Yes.
I believe I've already asked if there was anyone here to speak on this case. I know we had a late arrival. I just want to make sure we didn't miss somebody. Okay. Inspector, you have the floor.
Okay, Inspector Kat Reese, this is going to be for case 77-26 at 1004 South Martin Luther King Jr. Avenue. It's going to be also for permits required. This is specifically to repaving and striping of the parking lot. This was also about the same date. It was June of 2024, with the final notice being sent March 5th of 2026. And I did have to post for this specific violation to the property. And there's the location of the property again. And that's for the posting. And this is what the property looked like March of 2023, and as far as the pavement goes. And this is in 2025 and what it looks, February 2025 on Google. This was the inspector's photos of the initial inspection where it was repaved and restriped. And this permit that was pulled, I did quickly look to see if it did include this, and it did. So hopefully if they get everything submitted, they can come into compliance for this as well.
All right.
So compliance can be met by obtaining a permit and completing said permit with final inspections. Requested compliance by obtaining a permit on or before May 22nd, 2026, and completion of permit 6 months from the issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Thank you. Board, do you have any questions?
Is that a commercial
Yes,
zoning?
it is.
No further questions.
Any other questions? May I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second?
Second.
All in favor?
Aye.
All opposed? Motion carries. May I have a second motion, please?
I move to enter an order requiring the respondent to correct the violation on or before May 22nd, 2026. If the respondent does not comply by that date, the
May
board
22nd.
may order a fine of
Is it what-
Excuse me,
Did you say April or May?
May.
Oh, sorry.
Okay.
Michelle.
Board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. Next case, 3.11, case 78-26, find respondents A.A. Torres Pavan at 1450 Franklin Street in violation of code for permits, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Inspector Reese, you have the floor.
Okay, I'm Inspector Kat Reese with the City of Clearwater. This is going to be for 1450 Franklin Street, case number 78-26. It's one violation here for permits required, specifically permit required for the asphalt surfacing completed on the property. First notice, I apologize for that. That should say 2022. And I totally forgot to fix that. The first notice went out January 22nd of 2022, with my final notice being sent November 21st of 2025. Certified mail was signed on my notice from November 10th of 2025. This is going to be just northeast of Gulf Bay, right off of Franklin Street. So this is a complex, residential apartments, and this is what the property looked like on Google February of 2021, and this is it in February of 2025. This was also the initial pictures of the initial inspector. She did have communication with him per the notes, May of 2022, and they advised that they were going to work on getting a survey to come in compliance. Then when I took over the case, I did speak with somebody in December of 2025. Our conversation was a lot different. He doesn't agree that something so minuscule needs to be in compliance, and I've not heard from him again. So, compliance can be met by obtaining a permit and completing said permit with final inspections. Requesting compliance by obtaining a permit on or before May 22nd, 2026, and completion of the permit 6 months from the issuance of the permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
I understand from what you're telling us that work was done without a permit, and at some point with a previous inspector. Was that Nilda?
Yes, it was.
How is Nilda?
Oh, I think she's doing pretty good. I hear from other people that, that have spoken with her. She's enjoying retirement, I would imagine.
Good for her, she earned it. And then at some point, you picked up the case, and even though they indicated to her they would take care of it, now they're getting a different, kind of a different idea from them. That
Yes.
okay? All right. Have you spoken with them recently?
No, not since December.
Okay.
I would imagine he has realized it's a bit more complicated than just getting the permit, because it is issues with the right-of-way. It has to go through multiple departments. And a lot of people don't understand that, but there is importance to each one of those departments' approval.
Sure. All right. Any questions from the board? All right. May I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second?
Second.
All right. All in favor?
Aye.
All opposed? Motion carries. May I have a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before May 22nd, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
Chair? I'm
Yes.
sorry. The next item, 3.12, is the same address. It's a different case, but same address as 3.21. If we could hear those back to back.
All right, so we'll do 3.12 first, and then 3.21.
2-1, to not confuse you.
All right, thank you.
I don't know how they got separated. I'm sorry about that.
So we'll hear them sequentially,
Yes.
correct? All right.
Thank you.
All right, our next case, 79-26, fine respondents, and please forgive me if I butcher somebody's name here. Alexander Gabrichik and Shezhana Gabrichik at 1623 Windsor in violation of code for permits and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Nope. All right, Inspector Reese, you have the floor.
Okay, I'm Inspector Kat Reese with the City of Clearwater. This is going to be for 1623 Windsor Place, case 79-26. It's going to be for permits required is the violation, specifically the permit required for the screen patios that were installed on the property. First notice of violation was sent October 2023, and the final was sent March 5th of 2026. I posted to the property on March 6th of 2026. And this is going to be just north of Souvenir Drive, pretty far south of Union. So here's a Google photo of the property February of 2019, where you can see in this red box, it's just a balcony on the second level, and it's open at the bottom. And this is the Google photo August of 2022. So I have had communication with this tenant. He is advised that he has been having financial issues. I extended him multiple times. I said, I need some progress. Show me a survey and we can go to the next step. But there has been no progress towards coming to compliance. And I advised him he could come here and ask the board for what realistic time he thinks he needs, but I'm surprised he's not here. So compliance can be met by obtaining a permit and completing said permit with final inspections. Requesting compliance by obtaining a permit on or before May 22nd, 2026, and completion of the permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Thank you. Board, do you have any questions?
The person you talked to is the owner?
No, but he has since advised the owner, he's not in this state. He has my number as well. I've not heard back from any of them.
And the owner was sent notice?
I'm sorry?
The owner was sent notice?
The notice has to legally go to what is listed in property appraiser, so yes,
That's
and it
fine.
has been posted to the property.
Okay. Any other questions?
No.
May I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I'll second it.
All in favor?
Aye.
All opposed? The motion carries. May I have a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before May 22nd, 2026. If the respondent does not comply by that date, the board may offer a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
All in favor?
Aye.
All opposed? The motion carries. Per our secretary's request, we're going to jump down to agenda item 3.21, case 88-26. Fund respondents Alexander Gabrichik and Snezhana Gabrichik at 1623 Windsor Place in violation of code for permits and issue an order with the compliance deadline and fine if compliance is not met. Don't believe we have anybody here to speak on this, so Inspector Reese, you have the floor.
Okay, I'm Inspector Kat Reese, City of Clearwater. This is for 1623 Windsor Place, case number 88-26. This is going to be for one violation permits required specifically for the above-ground pool installed on the property. The first notice of violation was sent May of 2023, and the final was sent August 11th of 2025. Certified mail was signed, even though it was some time ago. I have been in contact with them, so I didn't post to the property since we did have mail signed by them in 2024. This is also for the same property. And this is an aerial view of the property, and this is from 2021 of May. And here, this is the property right here. And this is the pool that's installed. That also doesn't look very good on the aerial shot from February of 2023.
I'm sorry to interrupt you. Can we go back and look
Of
at that?
course.
I want to see, trying to see where that pool is. I know you
It-
probably can't zoom in on that. but,
Right, no, I cannot
is
zoom,
it
but
the-
it's
the
this
green
green
area?
area.
The green,
Yes.
Okay. That's a large above-ground pool.
It is a very large one. This, in the
Okay.
Google photo, I believe they caught them, like it caught a snapshot of them
I see.
installing it.
Okay. Yeah. Okay, thank you.
Yep. And again, the communication has been the same as the previous violation. He's been afforded multiple extensions to, for his financial burdens with no real progress. So compliance can be met by obtaining a permit and completing said permit with final inspections. Requesting compliance by obtaining a permit on or before May 22nd, 2026, and completion of permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Thank you. Board have questions?
No.
So you haven't been actually in communication with the owner. You've made calls and left voicemails, but you've never actually talked to them?
To the tenant I have, and,
But not the owner.
but I explained he wouldn't have to let his landlord know, and
Yeah.
the legal notice has been given, and if he is choosing to leave his landlord out, that would be a civil matter between the two of them, because we legally have to send to what is listed in property appraiser.
Okay.
But I have attempted, aside from that,
Yeah.
to have contacts with the landlord, and I have not received a call back.
Okay.
Thank you. Any other questions from the board? May I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
May I have a second?
Second.
All in favor?
Aye.
All opposed? The motion carries. May I have a second motion, please?
Inspector Reese, we're going with May 22nd again.
Yes, sir.
I moved in an order requiring the respondent to correct the violations on or before May 22nd, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Thank you, Inspector. So we will go back up to agenda item 3.13, which is continued to May 27th. 3.14 has been withdrawn. 3.15 is continued to June 24th, 2026. Next item for hearing would be agenda item 3.16, which is case 83-26. Find respondents DUN Investments Corp. at 435 Mandalay Avenue in violation of code for permits, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Inspector Reese, you have the floor.
Inspector Kat Reese with the City of Clearwater. This is going to be for 435 Mandalay Avenue, case 83-26. This is for one violation, permits required, specifically for permits of 4 wall signs on the property. First notice of violation was sent June 4th of 2025, and the final was sent on March of 2026, posted to the property March 5th of 2026. That's a picture of the posting. And this is right off of Mandalay Avenue, just south of Papaya. It is the Italian Forlini's restaurant. I have been in contact with the property owner, or the restaurant owner. This sign we had discussed, he said he would take down and not permit, but the other 3 would need to get permitted. So this, I know it's very difficult, it's like inside there, but it is easy for him to take that one down and come in compliance. But he still would need one to keep for this sign on the side, which is for his deliveries, as well as in the front of the business. And I have gone over, I believe I'm missing one other sign in my photo, I apologize for that. But he understands what signs need to get permitted. I've worked with him for a long time. I don't know what happened. He said he's gonna get fast signs to pull the permit prior to today. And I haven't heard from him, and there is no permit in the system as of today. So compliance can be met by obtaining an issued permit and completing said permit with final inspections. Requesting compliance by obtaining a permit on or before May 22nd, 2026, and completion of the permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Thank you. Board, do we have any questions?
So this is only affecting the 2 outside signs?
There are a total of 4. He could bring it down to 3 that need to get permitted, but if he takes that 1 down, but if he wants to keep it, it would have to get permitted as well.
Thank you. Any other questions from the board? When did you last speak with the owner?
He came into the office, and I sat down with him and someone from zoning as well as permitting just last week, or 2 weeks ago, and then he called me last week to let me know Fast Signs was going to get the permit in, and I haven't seen anything yet. I was rooting for him.
All right, thank you. Any other questions from the board?
And when would he have received his notice?
Oh, yes. It
No,
was
when?
posted to the property, when, June 5th of 2026.
June 5th of
No.
2020.
I'm sorry, let me go back to that. I'm going off the top. March 5th of 2026. I posted to the property.
But he got notices of violation in June of 2025 and September of 2025?
Right, so this would be the first notice of violation and the first compliance date, and then the second. So we give 3 violations before ever bringing it here, plus all the extensions that were given.
So the first one was like 10 months ago?
Correct.
Okay, thank you. Any other questions?
No.
May I have the first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
May I have a second?
Second.
All in favor?
Aye.
All opposed? The motion carries. May I have a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before May 22nd, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Agenda item 3.17 is continued to July. Our next case, agenda item 3.18, case 85-26, fine respondents Paresh Parekshak and Dhruti Parekshak at 440 South Gulfview Boulevard in violation of code for permits, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Inspector Reese, you have the floor.
Okay. All right, I'm Inspector Kat Reese with the City of Clearwater. This is going to be for 440 South Gulfview Boulevard for unit number 308, case number 85-26. This is going to be for 1 violation for permits required, specifically for a completed permit required for the interior remodel. So there have been multiple notices of violation sent, a total of 4, with several compliance dates. The initial compliance notice of violation was sent October of 2020, the final being sent November of 2025. Posted to the property, that was a stop work order the day of, on October 19th of 2020. That is the picture of the posting of the stop work order. This is going to be on South Gulfview. Just to give you, this is the 2-tower building at 440. The inspector, the initial inspector was able to go into the property where the work was evident. As you can see, it does include electric.
It does.
So I know some of these pictures are a bit blurry, but I tried to keep them all in there. And picture of the drywall. So the permit was pulled to come in compliance back in 2020. That permit has since expired. Okay, I have attempted to contact them. I've never spoken to anybody at this property. They have passed some inspections, but they also have failed some. So, and it does not include the electric. So even if they pass all this, they're still not in compliance until the entire scope is met through the stop work order. So compliance can be met by obtaining a permit and completing said permit with final inspections. Requesting compliance by obtaining a permit on or before May 22nd, 2026, and completion of permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Thank you. Board, do you have any questions?
I do.
Yes.
Is this the lobby of the
No,
tower?
this is unit number 308.
Oh, it's a unit. Okay, good. Thank you so much.
Okay. Any other questions from the board?
Has the unit been sold since?
No, still the same owners.
Same owner?
Mhm.
Okay.
If you haven't spoken with the owner, how did you get in to take pictures of the
The
insect?
initial, I wasn't here in 2020, so I
Okay.
took this case over from the previous inspector.
Oh, I see.
They went on property as well as air quality, because it's a condo, asbestos,
Yeah.
all of that, it was done, they did their inspection.
I
So the
see.
violation is there.
So it's been there, so it could be completely remodeled.
Oh, it definitely, I'm certain it is at this
Okay.
point, especially with the permits that they've
Okay.
had. The work is already done, but that, we need
Right.
to have past inspections
Sure.
on the entire scope of work.
Absolutely, yeah.
So the initial was in 2020,
Yes.
and then there's quite a time period from then up to, 2025, when it was picked back up again. I would assume there was, either it got dropped, or there was COVID, or there was work being done that was permitted, and then they stopped, or some such thing? Can you enlighten us on any of that?
Based off of the notes, and Nilda was pretty good, this was her. She was in contact with a lot of contractors for them to come in compliance, which they did in 2020. And then she closed out the case because the permit was issued. And that's, over time, they've learned that's probably not the best idea, because then we don't know if the inspections were done. So it goes in a different status today. It goes in a permit issued status, and then a reinspection would be set for 6 months from the issuance of the permit.
Am I correct in thinking that code compliance doesn't close them out now until the final inspection, and then you close your case?
Yes. How I work that, a lot of people would tell me, hey, I passed this and I'll close it out that day, but even if they don't tell me, I set a re-inspection in Acela, so that way it aligns with the permit, so that way I'm not confused going forward.
Got you,
Yeah.
thank you. Any other questions from the board? May I have a first motion, please?
I'm going to make a motion for address 440 South Gulfview Boulevard, Unit 308. Is that correct?
Yes.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second?
Second.
All in favor?
Aye.
All opposed? Motion carries. May I have a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before May 22nd, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? The motion carries. Just as a side note for looking at the administrative side of thing, I would assume, Madam Secretary, when this order is issued, that it will have that number 308 on it. 'Cause it's not shown on our agenda item, and I just want
I'll go back
to
and
cross
look
my
at the file
Ts and dot my Is
Yeah.
before I sign something.
Gotcha.
All right, excellent. Thank you very much. Appreciate that. Our next case is agenda item 3.19, case 86-26, fine respondents Bond and Ryan Sanhamel at 640 Bayway Boulevard, Unit 304, in violation of code for permits, and issue an order for the compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Inspector, you have the floor.
Good afternoon, Board. Reed Ito, Code Inspector with the City of Clearwater. This is for case 86-26. Property is located at 640 Bayway Boulevard, Unit 304. There's one violation for permits required, Section 4-203.A.1, specifically for permit required for interior remodel, including electrical and plumbing. I took this case over from a previous inspector, so the initial notice of violation was sent on May 6th of 2022. And I sent out the notice of violations on July 21st, August 15th, September 30th of 2025. The compliance dates was on May 24th, September 5th, and October 20th of 2025. And the certified mail was signed on the dates below. Here's the the map of where the condo is located on Bayway Boulevard. This is Bay Shores. This is a picture of the exterior of the building of Bay Shores. Here's pics of the remodel that was done on May 10th of 2022, where the previous inspector took these pictures. So when I sent out the notice of violations initially last year, the previous owner did reach out to me. But since then, I didn't hear anything from them till March of this year. So the previous owner and the current owner did reach out to me once they got the notice to appear. And this is what it looks like after the remodel.
Wow.
And compliance can be met by obtaining a permit and completing the permit 6 months from issuance. Requesting compliance by obtaining a permit on or before June 24th, 2026. And completion of permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Thank you. Board, do you have questions?
I do. Why so long for the permit? Just out of curiosity.
I'm not sure.
I don't think I understand your question. Why are you giving them 2 months?
Yeah, why are you giving him 2 months?
Because they are working on it. They came in contact with the permit tech,
Okay,
but we have nothing submitted so far. But they've been in contact with us.
okay, thank you.
And when you say they, was that
The
a
current
contractor
owner
or the owner?
and
or-
the previous owner.
Okay.
So the previous owner is helping out the current owner to get everything permitted.
Oh,
Okay.
so-
And this is multifamily, correct?
This is no, it's a condo.
Condo?
Yeah.
Okay.
Is it a 55 plus, or is it just a regular?
So it's, oh, go ahead.
Go ahead.
It sounds like the previous owner did the remodel? That's, okay,
So she's helping out the current owner to get everything done.
okay, thank you.
Okay, and you say they've met with the building department?
They were just making telephone calls and emails with us.
So they had a permit at some point for some of the work.
Yeah, but
They didn't
everything
have it
was.
for all of it.
Yeah, there's
So-
nothing approved.
And nothing, so nothing got passed or anything like that?
No.
They just kept going and, okay.
So they're gonna have to open walls and everything?
Say that again?
Are they gonna have to open walls and?
Yeah,
And
I mean, there are a number of ways to do that. If they get an engineer to sign off on it, but basically everything's got to meet code and you have to proof that up. I'm not speaking out of turn. Yeah, they'll have to get into compliance. All right, any other questions? All right, may I have a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. May I have a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before June 24th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines or fees, I'll give you that again. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. Second.
Thank you. All in favor?
Aye.
All opposed? The motion carries. Thank you, Inspector Ito. Our next case on our agenda is 3.20. It's case 87-26, fine respondents Gratis Filius Enterprises LLC at 1700 Gulf to Bay Boulevard in violation of code for unsafe building, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case?
Yes.
Okay,
Matt Blackshear with Hudson Bowen.
please step up to the mic if you will, and give us your name and address and your involvement in the property.
I'm Matt Blackshear with Schutz and Bowen here on behalf of the fee owner of the property, Gratis Filius Enterprises. Gratis Filius is the fee owner of the property. That's the owner of the land. The owner of the land ground leased the property to a tenant, 727, Wake Up 727, who was going to build a Caribou Coffee on the site.
Got you. And I don't want to interrupt you unnecessarily. What we'd like to do is get your information on the record and then find out the other gentleman here and what his involvement is,
Yes, sir.
and then ask a question.
I'm James Wardell. I'm here on behalf of Wake Up 727, which is the tenant.
Oh, I see.
Okay?
I'm sorry, your last name again?
Wardell, Wardell.
Thank you.
Okay, so you're both here, you're here representing the owner of the physical land
Correct.
property, and you're here representing the tenant for the
Correct.
property.
Yes, sir.
Okay? So our typical process here is that we like to ask you if you admit or deny the violation so that we can get that on the record, and then we'll go from there. So do you admit or deny the violation?
I deny the violation as it stands today.
Okay. Very good. Do you have anything to add to that, or?
I think the process is going forward. It was a violation, but it was because of reasons beyond both of our control.
Gotcha.
Now we're working with the city to fix it all, so.
Gotcha. So I'll ask you gentlemen to have a seat. We'll hear from the code compliance officer, and then we'll bring you back up and see what you have to say.
Good
Inspector?
afternoon, Board. Inspector
afternoon.
Larson, City of Clearwater. This is regarding 1700 Gulf to Bay Boulevard. It's a Caribou Coffee location, case number 87-26. We have one violation, property maintenance requirements, minimum building and fire code requirements. All buildings shall be maintained in accordance with the Florida Building Code, the Florida Fire Prevention Code, and the International Property Maintenance Code. Section 3-1503, nuisances. The existence of any of the following specific conditions or conduct is hereby declared to constitute public nuisance. Buildings which are abandoned, boarded up for a period of 6 months, partially destroyed for any period of time, or left for a period of 3 months in a state of partial construction. This is where we're at here. Provided that any unfinished building or structure which has been under construction 6 months or more shall be deemed and presumed to have been left for an unreasonably long period of time in the sense of this subsection. Notice of violation here was January 30th, 2026. Compliance date, 27 days after receipt of the notice. Certified mail was returned signed on February 23rd, 2026. Here's the location. You can see it's west of Keene Road, north of 60, right on Gulf to Bay there on the corner. Here's on the 30th, when we notified them of the unsafe. At this point, it was an abandoned construction site. You can see debris, the silt fence has fallen down. It's been sitting there a while. Piles of dirt, site, more site. Again, this is all on the 30th of January. Here's an open trench. Okay, now here we are on March 30th. Up close picture. There has been some site work at this point. We'll get into why or how. Again, site work. Now this is April 14th. There's a difference in the appearance of the structure at this point. It's looks like it's being demoed. There's people working on it. Same thing. Windows, debris. You can see the structure is open in the background there. Pipes exposed. Same thing. Again, this is the 21st. excuse me. Starting here is the 21st, which is yesterday. So this is what it looks like right now, basically. All right, this was an abandoned construction site with permits that had expired last year in July 22nd, 2025. That was for the build of the structure. 8/21/25 site work, both expired permits. There is an active permit now, dated 2/10/26 for the new build repairs and site work. A plans amendment 4/17, so 5 days ago, for additional repairs. It looks like they got into it and it was more than they expected that had to be fixed. Owner states that the contractor has been changed, so that's where we're at. Basically, for compliance to be met, to comply, construction needs to be completed to meet minimum code requirements with certificate of occupancy. If not completed, the remaining structure needs to be demolished. Recommendation in this case, if the violation continues to exist by October 22nd, that's 6 months, impose a fine of $250 per day. If the construction is not completed and a certificate of occupancy is not obtained by this date, the city asks the board to authorize entrance onto the property to correct the violations. The city will correct the violations by any means necessary with all reasonable costs to be applied as liens against the property. Standard. Basically, what we're looking for is a timeline. You can see they now have permits. They seem to be finding more work than what was there, what was expected probably. Actually, the previous contractor, the work they did, no inspections on a lot of it. A lot of the work, it's not done to the plan set, so you see their situation.
Okay, thank you. I have a question for you. Help me understand if originally they got permits, work was performed, work was stopped, but now they have a new permit in place as well as an amendment they filed.
And a new contractor.
Help me understand why this is before the board today if they, granted they had this period of time there, which I understand, but if they've got new permits and have an amendment filed to, provide the data for whatever changes they're making, then why is this before the board today?
Excellent question, sir. The city is just looking for some type of timeline. We want to make sure that it doesn't end up abandoned situation again. We want to keep it moving and have a nice building there when it's done.
Okay, I got you. All right. So you're basically in the business, since it sat so long, you're looking for a bit of motivation to make sure this thing moves along.
Yes, sir.
Any other questions from the board for the inspector?
Well, you see activity there. Do you think that that's new activity or that it took place?
Well, there's quite a bit of new activity, absolutely, sir.
Okay, so where's the 3 months? What are we going for here? It doesn't look like it's abandonment. It's not complete,
At this
but there are
point, it's not,
permits.
because the permits have, typically, when a building sits for a while, when the code board comes in, things start to happen, and that's what we're looking for. We want to just make sure that
Right,
this
but
project continues.
What motion do we do that makes sense at this point?
Not yet until we hear from the, I want to hear from
Okay.
the land person
All
and
right.
the, I'm sorry, I'm not here. I hope
Okay,
I'm not
I'm
stepping on
jumping
your
ahead.
toes. I want to hear from the owner and the tenant to kind of get their perspective of what's occurred and where they are with things so that we can
Okay.
better evaluate. Okay. Any other questions for the inspector at this point?
I guess I think what he was saying is usually when we get these cases, it's 3 months of a violation, and they've been given 3 violations and they're not doing anything about it. Well, now, yes, there was a period of time where nothing was being done, but they are doing stuff. There is an active permit. So I understand where you're coming from, but I think that's where the confusion lies, is if they have it.
I understand
You know.
what you're saying. Yes, ma'am.
Yeah. Okay, no problem. Thanks.
Thank you. Gentlemen? What would you like to tell us about all of this?
I can provide some background information. I think you've all had very rational and reasonable questions, and I think that the position of the inspector is pretty reasonable in light of what's all going on. But just to provide some background color to it, this isn't a situation where somebody's trying to do something and abandon a project and walk away. When this ground lease was signed, there was a requirement of the tenant who was going to raise the existing building on the site, and they did. But there was a requirement that the tenant also procure a payment and performance bond from its contractor, because we didn't want to be in a situation where there was a half-constructed building and nothing, you know, the tenant, either the tenant defaulted or the contractor defaulted or whatever, it didn't go forward. We didn't want a bad situation, so we required the bond. The tenant got the bond. And then things went sideways with the contractor's work. As I understand it, again, I represent the landlord, not the tenant. But things went sideways with the landlord, with the contractor. And then it took some time. I don't know if you've had to make a claim on a construction bond, but it takes some time to go through all that process. And then, of course, then it's finding a new contractor to come in and step into those shoes, which I understand has happened here. And then I think everyone's probably experienced at some point, if you've ever terminated a contractor and got another contractor, and there's a problem with the prior contractor's work.
Yeah.
So you got to go through and you got to do this additional work. And I understand these pictures are from the stucco. And the problem that with the installation of the stucco, and that led to some other problems. There are active permits here. I received emails as recently as this morning about a modification to the description of the work in the permit, just to make sure it's all picked up on, to make sure the inspections are done. But this isn't a project that someone is just trying to, you know, abandon, walk away with, create a nuisance, anything of that nature. What I would actually request, and I think that the proposal is fair, but what I would request of the board is that we just continue this to a couple months from now to let the board revisit it. The tenant is already under a fine per day, so to speak, because the tenant already has to pay to my client rent, what it's doing, and it's not generating any money from this property. And so the tenant is under every urgency right now to get this project completed and open. So I don't think that, the purpose of a fine is, of course, to ensure and persuade compliance. I don't think that that's really necessary here. So with some of that background information, I hope the board would consider just continuing this for a couple months, and I'm confident that if it comes back or if this is canceled, that it won't even be necessary.
We're asking for 6 months. So.
Well, right, and I think that's fair, but I just meant to continue the whole concept, this entire hearing, because as you see, the contract already started, and then it turned out they had to pull the side of the building off.
Right.
And we just don't know what's going to come up. And I understand the concern about the timeline on it. But again, please consider the situation that the tenant is in, which is that it's paying a substantial rent to my client, the landlord of the property, every month going forward, while this is sitting here, while it's not generating any revenue. So it's already not in a favorable position, and it has every motivation in the world to get this done as soon as possible.
Right. Regarding, from what I'm hearing from you, you're asking us not to oppose immediate fines, and that's generally not our operating basis. I believe the inspector is asking, for if work is not completed in 6 months, at that point, instituting fines, if I read your request properly. So understand that we're not in the business of assessing fines immediately today. We're in the business of saying what's going on here, what's it going to take to complete, what's fair, et cetera, and what's the inspector asking for. My question, are you involved in the construction end of things? Are you conversant with that, or should I be talking to the other gentleman?
He's probably more familiar with the actual construction aspect of it.
The reason I'm asking this is that, please step up, sir, if you would, is that our inspector is asking for, is saying that he's providing a 6-month completion time, and my question to either one of you gentlemen is that a real timeline to get the project completed?
We think that's a real timeline. In fact, we're hoping to be done sooner than that. As everyone said, we've been paying rent on this, and my client was really kind of a victim of construction worker, and fraud, and we had him on 2 other buildings that they did in Pinellas County too, so we had to correct all of those. So we went as fast as we could, taking the bond. As soon as we resolved the bond matter, there is litigation with the former contractor, but that's not part of this. We want to get this done as fast as possible. It's been a huge expense for my client, and nobody wants to get it done sooner. We do have the 2 contractors and the subcontractors. We're working on the case in case you want specific updates. But a very aggressive timeline is maybe 60 days, more realistic, because we know stuff always comes up. we don't think we'll have any problem completing everything in 6 months, so.
Does the board have any questions of these gentlemen?
Is it a coffee shop that's going in?
Caribou Coffee, yes, best coffee in the world.
Thank you. Any other questions of these gentlemen? I see Mr. Garrett's come forward. Did you have something to offer, sir?
Yeah, hello, board. Kevin Garriott, building official. This is an unusual case. As you said, and as you noted, we've got a permit. But I also want to remind you that we had a permit for about 2 years and it sat like that.
Yeah.
So we're at no further than we were 2 years ago when they started building it and left it looking like this. So the motivation that somebody mentioned here is exactly what we're looking for. We want you to push them to get that CO, and if they don't get the CO, they can have some fines on the property and take care of it that way. All the rent, I'm sure, has still been due all these years while it's been sitting like this. Nothing has changed. These gentlemen talk about, you know, where they are now. Same place we were 2 years ago.
Excellent.
Thank you.
Thank you for that information. I appreciate it.
The only thing I would add to that is that there were construction defects in what we were looking at 2 years ago, and that those are being resolved now. I'd also keep in mind that the fines that are going to be assessed, if it's not brought in compliance or gotten the CO within that 6 month period, they go against the landlord. And the landlord's fee simple interest, who's standing back with his hands in the air saying, this is my tenant doing this. Although if it sounds like they can get it done in 6 months, that would be great. If the board would consider maybe a little bit extra time just for the landlord's protection, we'd certainly appreciate that.
Well, I would like to ask the inspector a question in that regard. Is it your typical operating basis that if you see a project progressing and moving toward completion, that you're typically in communication with the owner and or whoever else is involved to check status before you bring it back before the board?
Absolutely, sir. They've been in great communication with me since I've been involved. And like you said, if we see improvement, passing inspections, that sort of thing, you know, we don't usually push the issue. You know, we give them a little bit of leeway.
If you see progress, you're willing to work with them? Is that a fair
Yes, sir.
statement?
If we see progress, we're willing to work with them.
Does that help answer your concerns and questions?
Yes, it does, as long as we're in good communication as well.
Good. All right. Any other questions from the board? All right.
I want to know what the violation is, the current violation that we're doing a motion on.
That would be a question for the code compliance officer, inspector.
Well, at this point, sir, it's still an unfinished site, so, but they do have permits, so they are moving forward. As far as the violation, you know, the nuisance, it's been a nuisance, and we want it to be taken care of.
Can you bring back up the code that we're basing this on?
Yep. Is it at the top or the bottom? Yeah, it's on the top. Yes, sir.
Okay, so, yeah, it's kind of small, isn't it? So I'm looking at, under the second section there, nuisances, buildings which are abandoned, boarded up for a period of 6 months, partially destroyed for any period of time, or left for a period of 3 months in a state of partial construction, et cetera, et cetera. That's what you're basing your request on.
Yes, sir.
And the timeline on this is, I believe, I heard from Mr. Garrett, it's been going on a couple of years or some such thing, and,
It's been going on for a while, so.
okay.
They're comfortable with 6 months. I think that's reasonable for everyone, and
If I could just add, and this is the reason why I asked the board to continue the whole matter for 6 months or so, because there's a presumption that a site's been, if it's under construction, it's been longer than 6 months that it's abandoned. That's just a presumption, but I think we've overcome that presumption in saying by the issuance of the new permits and the activities and saying that that's not the case here. This isn't an abandoned site. They are doing work on the site and they're moving forward. So I don't think we're in technical violation of this at this point. That's why I denied the allegations at the outset. And that's why I asked that we just continue the hearing along. It would seem more prudent for 6 months from the issuance of the permit for us to be back here, but I'll leave that for the board.
Okay.
Mr. Chairman,
Yes.
I think what he's saying is prudent. I think we should probably continue this for 3 months, hear it, and then, if they're not moving along, we have ample time to act before the 6 months from now is coming in effect. I think we just delay this for 3 months and get an update.
Understood. From another perspective, if the compliance officer is asking for 6 months and they think they can finish it in 3, and no fines occur until, before the inspector brings it back before us 6 months from now, then I understand the compliance officers and the building department's desire to, I know that the owner and tenant are motivated now by the fact that this thing has gone on long enough and they want to see it complete and they're here to talk with us. I think that, number one, they're motivated by having to pay rent. And I certainly understand the city inspector's point about wanting them to be motivated. I think they are motivated, but again, I'll point out that no fine or action occurs, number one, before the 6 months, and number two, before the inspector brings it back before us. And so from what the inspector is offering, I see no harm, no foul by going with a standard motion unless there's something that I'm missing.
Even if we just look at a 3-month extension with no fines, we're not violating what you're saying either, it's just that we're reviewing it at that time.
Well, that puts it at 9 months out, though. If they're asking for 6 months now and we wait 3 months to hear it
No,
again,
It's just
Then we
3
can-
months from today.
Yeah.
I'm
And
sorry?
If we,
Let me ask you
if,
a question again about, I think you may have told us, but let me ask again. During those 2 years, what was happening that was keeping you from going forward?
So the contractor basically was defrauding my client. They paid the contract in full, and they kept saying it was almost done, almost done, almost done. They finally had to get kicked off the project. Then there was a bond, and the bond had to come and inspect to see the violations. So we weren't allowed to change anything until they did the inspection to pay for kind of the fraud that my client suffered. So it just, nobody wanted it to take this long. My client was very frustrated in trying to get the contractor to go the whole time. So it just took that long for the process to unwind. And like we said, we've been paying rent on this the whole entire time. And, it's a prime piece of real estate on a busy corner, so it's cost them a fortune. And we are suing to try to get that back, but who knows, we're just trying to get the building done so we can generate some income. So this was not any delay. This has been really, they're essentially victims of kind of a horrible experience here.
What's your best estimate of completion of construction?
If everything went perfectly fine, 60 days. If, we run into some other things, we think that 90 to 120 would be kind of the outsides of how long it would take.
So if we wait 3 months from today and get an update, we'd have a pretty good update.
Yes, we'd have a really good update, and we might even be close to completion at that point. So I think that's a very fair suggestion, and after that, you could just set another 3 months, so you wouldn't be out, it wouldn't turn into 9 months, it could just be 6 months at that time.
All right, I'm going to make a motion that we just continue this for 3 months and hear it again for an update.
Second.
Is there any other, before we rule on that, we've got a couple of different points of view here, and I want to make sure we sort this out to the best interest of all concerned. Not to quash anything you're doing, I want to make sure we're all good with this.
We have a motion on the floor now.
Say again?
We do have a motion on the floor.
Well, you have discussion upon the
Yeah.
motion.
Yeah.
Can I ask a question? If we were to do the 6-month fine, but let's say hope this never happens, but in 5.5 months comes along and they're like, we're still waiting for this license to come in or this inspection or whatever, and it's gonna take another month, can they come to you or can they come to us and say, we need an extension on this?
Absolutely.
Okay,
And remember, you have to accept an affidavit of noncompliance in order for the fine to run. So number one, the city has to present it to you.
okay,
And
again,
that's- Right. So
Okay.
if the city, if things are working out, then the city's not going to bring an affidavit of noncompliance.
okay, good, okay.
Mr. Chair, may I add
Please.
a word? I would just say that I don't necessarily have an objection to the continuance. I think if we did do it that way, the city would come back in 3 months and ask for the exact same deadline date that we're asking for today. The only difference is adding a hearing in between those two timeframes. I think from their perspective, there's a difference also in the determination that a violation actually occurred, which I hear the conversation on that. And I would just say our perspective on that from the city is that notwithstanding the activity that's occurred, the litigation, the frustrating circumstances, the code does specify that if it's left for a period of 3 months in a state of partial construction, I don't think we've heard any real debate about that fact, that it has been in a state of partial construction for a very long period of time. So that's our theory of what the violation is. Defer to the determination of the board of what's best and whether or not you want to hear it one more time before the deadline. If we come back, we would ask for the same deadline in October. And then, as others have stated, if there was significant progress occurring in October, the building department would have discretion to bring that affidavit back at a later time or not. And the landlord and the tenant, the participants here, would have another opportunity to come on that day, and we would again be arguing the point of whether or not it has been left in a state of partial construction at that time. So there would be another opportunity to debate the issue of the status of the construction and those sorts of things.
So the only difference between those two, if the city came back with the same date of October, if we did an extension that the owner is asking for now, the only real difference between, and they came back with the same date, the only real difference between the two would be that we're not making a declaration of violation today.
I mean, I don't want to necessarily speak for them, but I assume the reason that they're asking for that is because that does give a possibility to allow them to resolve the situation without a formal finding of a violation. So I understand that, why they would ask for that. Like I said, you've heard from our team, we're just trying to get significant progress. We understand that this has been a complicated situation, but our code does, the permit issues, the contractor issues are their own separate thing in terms of whether or not something is a nuisance. And from our perspective, the fact that it's lingered in a state of partial construction well beyond the time frame that the code requires means that it is a nuisance in our determination.
And remember, if you find a violation, they're subject to the higher fine for repeat violation. So once you find one violation, they would come back as a repeat violation. You're looking at up to $500 per day.
Understand?
Yeah, if I could, the only other thing I wanted to add is that I still don't think under this statute that there is a current violation. I think there is an insinuation or presumption in this statute that the building is still partially constructed and that there's nothing going on, and we know that that's not the case with this particular site.
Understood. Thank you. All right.
I'm just going to add, I hear two attorneys here in good faith giving us some good information, representing the landlord and also the owner of the property, and I think we should continue hear it again in 3 months.
I have no objection. Does anybody else have anything else to offer?
No, I have
before
no
we-
objections to that.
All right. Would you,
Motion's on the floor.
Motion and a second, it's on the floor. So, yeah.
So we can call for
I'm sorry.
We can call
One
for a
moment,
vote.
please. Counselor?
No, the motion and second's on the floor to continue this for 3 months.
Thank
So
you.
we need a date.
Well, let's get the vote, and then we'll get the, we'll tell you when it'll be on.
All right. I have a second.
Yeah,
All right. All in favor?
Aye.
All opposed? The motion carries.
So when's our next meeting in 3 months? July.
July, the 29, yeah, July 29.
So it'll be back before the board on July 29th.
Thank you very much.
And we
All
hope
right.
you can bring us
Thank you,
a copy
gentlemen,
that
for,
day.
for coming and bringing us all of the data and helping us understand
Please
this.
give us good information.
I thought you were referring to Mr. Simpson.
All right.
Giving you information? I just.
Moving on.
Yeah.
We've already heard, that was case, or agenda item 3.20. We've already heard 3.21. 3.22 has been withdrawn. And that completes new business items.
That is correct.
All right, moving on to old business. This is case 48-24. Consider request by petitioners RE Capital Management LLC at 1915 Macomber Avenue to reduce the fine regarding exterior surfaces and abandoned building, and if approved, issue an order that specifies a fine that includes administration costs and establishes a date payable, or the lien will revert to its original amount. Sir, you're here to speak on this case?
Yes, I am. My name is John Liu. I'm a state-certified building contractor, not the one that got fired from Caribou Coffee. Which, by
Thank
the
you
way,
for
is on
giving-
sale at Costco. The pods are on sale just at anything.
Thank you
$9 off, I think. a
for that
pod.
clarification.
And I am not the owner. I am an authorized person to appear, and Madam Secretary Nicole Sprague does have a notarized authorization on file.
Okay, very good.
I like these hearings for some reason.
Okay.
We have the authorization, and board, the administrative costs are $1,135.20.
1135.20.
Yes, sir.
And did you say that the city has, is in agreement with this? Or
I don't think he said that.
does this,
our-
let me
yeah,
ask you this, what is the city's position on this?
We just like to get our admin costs, investigative costs back from the case, but beyond that, we don't have any objection.
And what is that cost, do we know?
Yeah,
That's the
1135.
1135?
Yeah.
Yes.
Oh, okay.
Do you have any questions from the board on this, or any?
Sorry, what, is this the property that had the window that needed to be replaced, that's boarded up? What is this?
This is a fence, exterior surfaces, abandoned building.
And that's all been fixed now?
Yeah.
Oh, okay.
I'll point out that looking at the affidavit, it was owned, the owner died, his father lived out of state.
Oh, that's this one.
The property was purchased by a new owner, am I correct in this? And
I
the,
can add something, there is, I have
You do?
undiagnosed, I have undiagnosed OCD, and there is an incorrect statement in the application. The date of death states November 21, 2018, that if you look at the death certificate, the owner was found dead, sadly, at the age of 40, on January 18, 2021, so there's a little bit of dyslexia and something else going on there that I do not approve of, so let's go ahead and get that corrected if that's okay. Sorry about that.
Thank you.
I don't think that's gonna play a major part in
No, but I
anything
just-
we do, but
I
I
don't like to say
appreciate the
this.
detail, the eye for detail. Thank you very much.
Undiagnosed OCD, I can't help it.
No problem.
And I opened the cases after that happened, and the father did try to maintain the home, but just couldn't do it. He mowed it a couple of times, and we had to kind of take over, and then the lien started. Now they've stepped in, they've corrected the violations, and
Great,
supported lien reduction.
all right. Any questions from the board?
What page would this one be on?
Say again?
What page would this one be on?
I don't have that book, so. Somebody
is that
have that for
5?
Yep.
The top one?
Reduce lien, page 5.
And how many days are we going with?
It's usually 30, right?
Is it 30? What's the number of days on that?
Typically, it's 30.
30.
Sorry, this is the current lien amount. What are we trying to reduce it to?
We're reducing it to the city's hard costs,
The,
administrative costs, which
Oh.
are, I mean, we're entertaining the concept.
Oh, I see, it wasn't
Of-
on mine.
Right. No, it wasn't on mine either. They called it out.
Okay.
Okay? So that represents the city's hard costs and administrative costs.
Chair,
okay.
if I could just, and I apologize because we do have new board members. So you have a policy that doesn't allow you to reduce any kind of fine below the administrative cost, so that at least the city, on both sides, the enforcement and administration can be made whole. So that is your policy. So normally what we do in this situation is we'll read off, like I did, the amount, and that is your, the lowest you can go.
I see, okay.
Thank you for that.
And I just want to clarify, so you're working for the new owner who purchased the property and then made all the repairs?
Yes. Because I have OCD, some of the repairs were done actually before they became technically the owner. The
Okay.
fence repair was done way back.
Okay.
Waiting on the probate just concluded, and then that's when the rest of the repairs were done. But yes, that's correct.
Okay, thank you.
And then, of course, the hard costs, we don't want the city losing money in that way, so yeah,
Right.
definitely bring a check to Nicole like in the next 48 hours.
Okay, thank you.
Right to her house.
It's convenient.
I'm ready for a motion.
Okay.
Unless
So
somebody's-
everything's up to code now? Yeah?
Yes.
Yeah.
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 I move to enter an order reducing the amount of the lien to administrative costs of $1,135.20 payable within 30 days, or the lien will revert to its original amount.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Thank you, sir.
Thank you, board members, thank you, city attorney.
Thank you.
All right, we're moving on to other board action. And I'm assuming, Madam Secretary, we're allowed to accept all of these affidavits of compliance with one motion?
I'll allow it.
All right. So regarding all of the listed affidavits of compliance, 5.1.1 through 5.1.9, may I have a motion, please?
I move to accept the affidavits of compliance as written.
Second?
Second.
All in favor? Aye. All opposed? Motion carries. Next order of business is item 5.2, continued from March 25th. Case 188-25, accept the affidavit of noncompliance for respondents Angel Investment Group of Tampa Incorporated at 1039 West Avenue for permits.
We
Ms.
have no
Reese?
compliance for that property. I could bring up the picture as it stands today if you'd like. It was the shed slash, I believe, what they may have made it into a living space on the property that has not been permitted. What's that address again?
1039 West Ave.
Let me just skip to. Oops, sorry. There we go. So that was, as of today, this morning, this shed here, that has still not been permitted. I've had no communication from this property owner.
Okay. Anything else you wanted to add? All right. Any questions from the board? May I have a motion?
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. Item 5.3, case 191-25, accept the affidavit of noncompliance for respondents Richard and Nicole Pendleton at 3268 San Mateo Street for permits. Inspector Reese?
Good afternoon, Inspector Kat Reese. This is for 3268 San Mateo, case 191-25. Again, this property has not come in compliance. I believe when we brought it before the board, I did give ample time for them to get the flexibility that they probably would have needed to keep the pavers the way they were. He waited until today to contact me and is traveling at this time, so I did advise him that I would be moving forward with the noncompliance.
Okay. Board have any questions?
No?
May I have a motion, please?
Go ahead.
I move to accept the affidavit of noncompliance and issue an order that poses fines and states if fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Have a second.
Second.
All in favor?
Aye.
All opposed? Motion carries. 5.4 on our agenda, accept case 3-26, accept the affidavit of noncompliance for respondents Kathy Varro at 1910 Union Street for exterior surfaces, roof maintenance, door and window openings, exterior storage, and public health, safety, or welfare nuisance, which is a pool. Let's see, you aren't Inspector Casman, but we will gladly speak with you, sir.
Shrunk. Inspector Casman's on vacation, but I went by the property this morning and all the violations still exist. There's a fire at the property. There's stuff strewed around the property. Doors and windows are broken. Holes in the roof from the fire. And the unsafe pool and everything else that's on the property. So no change.
Okay. Thank you, sir. Any questions from the board?
Do you know if Inspector Casman has been in touch with the owner, or does he have any update?
I don't think so.
Okay,
But I do know that the property is foreclosed and scheduled for auction in June, so.
okay, thank you.
And
All
I
right.
think I just closed everything out.
All right, any other questions? May I have a motion, please?
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. Thank you, Mr. Stand-in Inspector. Next item, 5.5 on our agenda, case 15-26, accept the affidavit of noncompliance for respondents Wesson Road Investments Columbus LLC at 705 Vine for permits. Inspector Reese?
Oh.
All right. All right. Point of order, one of our counselors, Madam Secretary, this is for an affidavit of noncompliance.
That is correct.
And I am not familiar with our procedure in terms of how or if we entertain someone that's here to speak about the property. Yes? I'm
You
nodding
have,
here, yes?
it's at the board's discretion, but you have done it in the past.
Okay, any objection to hearing from the property owner?
She may have to be sworn in.
I'm sorry?
I don't know if she's been.
Were you sworn?
Oh, okay, you've been sworn in, okay.
All right. Please step forward and share your name with us, please.
Sure.
And who you are.
Good afternoon. My name is Lauren Fennessy. I'm here in representation of the owner, Weston Road Investments LLC. I wanted to share just insight on, you know, that no work has been done since the violation, and that we have obtained a new contractor who is expected to pull a permit on May 3rd.
Thank you for that.
You're welcome.
Would you like me to go through the whole slide
Yes,
considering? Okay.
yeah, why don't we, let us help us figure out what we're gonna do here.
Yes, okay, Inspector Cat Reese, City of Clearwater, this will be for 705 Vine Avenue, case number 15-26. And this was in reference to the interior remodel, including plumbing on the property. And these were the notice of violations that were sent. And then Vine is gonna be just south of Seminole Street, east of Myrtle Avenue. This was the stop work order that was on the that I posted on the property the day of the violation.
4/16/2025, am I reading that correctly?
Yeah.
Yes.
All right, okay, thank you.
That was the compliance date that they had to meet on that. And this was the property that I approached
Oh, my goodness.
with the workers on site. So obviously the work is done. There's no updated pictures to that, but I did provide a screenshot to show that there has been no permits pulled since we brought this before the board. And so the original compliance date was set for February 28th. They've actually gotten an extra month because I had to continue all my cases for personal issues. So at this point, I do believe that the non-compliance should go in until they come into compliance with the permit.
Okay, was all the work completed on this thing?
I haven't been in there since the day of the initial inspection, which I did advise to stop work, as well as PCCLB. So, if it has continued, I would not know, because I wouldn't try to go back into the property at this point. The violation is there.
Got you, okay.
Can we ask this
Yeah,
lady
I
over
have it.
here?
Ma'am, please come back and chat with us again if you would. Thank you. Help me wrap my head around what occurred here, because the way our process works, we typically will the inspector will find the violation, she'll issue her documents and her violation, and then you have some time to work with, so on and so forth. And we're very late in the game now in that the city's asking for affidavits of non-compliance after a year of this, and I'm don't have enough data to understand exactly what occurred and why this thing ran so long.
I know that we had an extension because we were in search of a contractor, but you know, when that stop order came, all work was ceased. It's still sitting, to my knowledge, it's still sitting untouched. You know how contractors are, they sign on and then, you know, sometimes they just disappear. So we've actually got secured a contractor now who is ready to pull the permit the start of May and go from there and keep everything in compliance from there. But we have not touched the property since we received that stop order. So.
Okay.
Well, can I just ask why they haven't been submitted yet?
Because we were in between contractors, we couldn't get a contractor to.
But you said they're gonna submit on May 3rd, why not yesterday or today?
Because they are finishing up another job, another contract. So before they dive into this one, that's the date that they told us. They haven't told us anything else.
Okay.
I would never want to be a contractor.
So they haven't submitted anything for permit yet?
Nothing yet, no. They just told us that they plan to pull either on or by the 3rd of May.
Okay. So that's, if they submit, then there's, obviously there's a bit of a waiting time before the permit is issued and work goes on and so forth. So I'm trying to reconcile the amount of time that this took, where we are now with a affidavit of noncompliance, and you know, how all of that affects completion of the property and what our best course of action is. So I'm welcome to any input
Mr. Chair?
Yes, please.
Provide some input. We have, in the past, we've had the board just delay making a decision on the affidavit of noncompliance. I think for this particular situation, because they do need to get the permit and they do need to complete all the work per the permit, it doesn't sound like delaying the affidavit of noncompliance is maybe the best route. It is in violation. They, doesn't appear that they're disputing that part of it. They've just had some trouble with the contractor. This could also be addressed just through the lien reduction process. Once they do come into compliance, they come back and they get a lien reduction, and that's where they explain all the difficulties that they incurred, and then the board could reduce the fine. I would just say that functionally, the difference that would create is that if the fines did accrue because the board accepted the affidavit and they have to come back for the reduction, then the city would be asking for the costs of the case. So they would have to pay that minimum at least. Whereas if the affidavit was, if you delayed decision on that, there could be, I guess, a possibility that the case could be dismissed if they were able to get it into compliance in between that time frame. I'm just giving you the different scenarios that I've seen in front of this board. I mean, our position at this for the city is that we did give some additional time beyond the deadline there. This could have come back to you last month, but it's here now, and we do think that they would have an avenue, at least some relief through a lien reduction if you were to go ahead and accept the affidavit today.
And this wouldn't stop any permits from going through or anything like that?
No, that wouldn't have any impact on that. The permit process is separate. So the hurdles that they have to get through there is that the contractor will have to have the plans in order, and they will have to meet all the requirements of the permitting. So, which it sounds like, that's something that, they are kind of dependent on the professional to take care of. We understand that difficulty too, but we have to operate with the deadlines and the frameworks that we have, so.
Okay.
And our typical,
We have,
And that's the city's position. Now, the ultimate determination is yours. So you can choose to do whatever you want. You can accept the affidavit of noncompliance, which would trigger the fine starting. You can wait. It's up to you.
okay? Yes, ma'am.
I have a suggestion that we just continue until next month and
Okay.
see if their permits are in place.
If I could add, if I had communication on this matter, I wouldn't have brought the noncompliance, but I've had no communication
Okay.
about that. And, at this point, like the attorney advised, they could just do the lien reduction, but we need to make sure that this is up to code through a permit. And we're not even in that property to understand if everything is safe there. And we can't just go off of hearsay with no proof of a quote or anything from a contractor, because that's typically what I would ask for. All right, let me get the quote and we can continue this, but that has not happened.
There's no quote from the contractor?
No,
And
Okay.
no application of permit submitted yet?
no, sir.
Okay.
Okay.
Ms. Reese, on your recommendation here, I'm reading this, and it says, requesting compliance by obtaining a permit on or before 2/28. That time has passed.
That was the initial,
Right.
Yeah.
that was the initial order.
Okay.
So could we change?
So now we're just doing that was the initial. And
Correct.
so we're well beyond the 2/28 by about, not quite 2 months.
Yes.
Okay. And so we would be doing if we move forward, we would be doing an affidavit of noncompliance.
Starting at what day, though?
I mean, that's not, we're not giving them
No,
time.
the fines will
It's
not
basically
start
5
until
days.
you accept the affidavit of
Okay.
noncompliance.
It's just an accept the affidavit.
If I
Or
may,
unless we decide to continue it or
and
do something
when is
different.
your contractor supposed to come on board?
If you could just come to the mic. Come to the podium. Thank you.
I don't know if I was in it. May 3rd is the date.
Counselor, you had something to offer?
Yes, Mr. Chair, thank you. Just, again, position of the city, but the order that this board rendered gave the initial deadline of 2/28, so that's already in an order. If the permit was issued on the very day that the contractor came on board, they were able to come in and apply and get a permit on that day, May 3rd, I believe. They would still be in violation with the previous order. But that would, I guess, create some avenue with the second part of the order, which is the 6 months, to complete the permit within 6 months of the issuance of the permit. So it would be some kind of hybrid in terms of determining whether, they were in compliance or not. That's why I was suggesting that accept the affidavit and then allow for lien reduction if they were able to come in. But certainly defer to the board on how you want to determine this or handle this. But the possibility of meeting that February date is gone. So,
Thank you.
Do you know the date that you first requested the compliance by February?
The first compliance date was set for for April 26th of 2025, based off of the first stop work order. And then multiple compliance dates were given after that.
Okay, but the one that ended up with, the one that's triggering this from 2/28.
Oh, yes,
What was the hearing date for that one?
I believe it was, this was
Was that
brought before the board in
January?
January.
January,
Mhm.
okay.
All right, I would,
So they've had almost 3 months.
yeah, I would entertain a motion to accept the affidavit of noncompliance.
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
Thank you.
Thank you. All right. The rest of you probably are not aware, but Madam Secretary told me that case number 1626, which is next on our list, is going to be continued until May 27th. So we will move forward to agenda item 5.7, case 18-26, accept the affidavit of noncompliance for respondents Wolf Empire LLC at 1738 North Fort Harrison Avenue for permits.
Mr. Chair?
Yes.
Yeah, I just, food for thought, certainly defer to Madam Clerk and Mr. Salzman, but if we have an affidavit of noncompliance, that is a sworn statement from our side that it's in noncompliance, and it's at least the position of the city that you could accept those without a full-on presentation unless there was someone here, like in the last case, where they had input for you to hear on that matter. Otherwise, I think you can accept the non-compliance affidavits in the same way that you accept the other affidavits without objection in bulk. That's my position. I'll certainly defer to the clerk and the board attorney, or I don't know if any of the other staff have a different view on that, but that might save us a little bit of time.
Why would we continue it anyway?
Well, if I can offer, my only thought as chairman was to be considerate because the owner was here and willing to provide data.
Certainly.
and
If
that
the
was-
owner's here, I think that the board has to hear it from the
Right.
owner, always. But what I'm suggesting is that for the other affidavits that are submitted,
Yeah.
if there's no one here to offer any additional, that is an affidavit that you could just accept
Without having the
without
inspector.
a full-on presentation. That's my personal opinion. I certainly defer to others if they want. It might save us some time.
Do you understand, everybody understand what he's saying? That if there's nobody here to speak, that rather than hear from the inspector regarding the affidavit of noncompliance, we could simply accept it?
Yes, but what I'm trying to clarify is, who asked for this to be continued?
I asked for the continuance. The property owner came here. She did show me pictures, and I advised her I need to come there in person. But considering that she showed me some proof of evidence of compliance, I want to afford her an inspection, she thought that I would just pop up again without, being scheduled.
So what I'm saying to you all is that the city inspectors asked us to continue it.
She did?
This one that we're reading right now, or?
No, this is for, the continuance was for Mission Hills.
I think that was the previous
1626.
one,
The
right?
previous, yeah.
Then I don't understand why we're not just voting on 5.6.
Because that,
That is the one I asked for.
Oh, I see. what we're doing.
Then I'll go back to what I just said. Then if the inspector is asking us to continue it, why wouldn't we continue it? Because they're the ones that are going to determine whether or not
I
subsequently, if we get an
understand. I'm sorry.
affidavit of
Now I
non-compliance
understand.
or compliance. To my respected colleague, I would say if the city's asking for this, and that's why I wanted to bring that before you.
Sue, you're suggesting we make a motion for continuance rather than just pass it over?
Right,
And-
because that's what we're being asked to do by the inspector, to
Oh,
make
okay.
sure that, if they come in compliance, right, then we're not going to bring it back.
Right, I would.
Yeah, so that's what,
Okay.
yeah.
So the city's requesting a motion to continue case 16-26.
yes.
Not the city.
The inspector is.
Yes, okay,
Yes.
okay, good.
I'm sorry, this was day of, she was here.
This is, this is odd for us. We don't do this real often, so.
Right.
Right, no.
This is new to me
Good.
too.
All right, I would entertain a motion to continue case 1626, please.
Second.
No, I'm looking for a
No,
motion.
he's looking for a motion.
I'm
No,
looking for a
I'll
motion.
make the motion that case 16-26 is continued until May 27, 2026.
Now you can second.
Second.
All right, all in favor?
Aye.
All opposed?
Thank you.
Case is
Okay.
continued. Thank you. Thank
Mr.
you.
Chair, if I may, I think we may have been talking about two
Yeah.
different
Yeah.
things.
Yeah.
Yeah, that's why
Yes,
we got
I
confused.
finally figured that out.
I follow now,
I
okay.
think it was actually 3.
No, absolutely, you don't have to have anybody here for you to make your, on
No,
these, accepting these affidavits.
I get that. I mean,
Okay.
I tend to lean in the direction of manners, and if somebody's willing to show up and be here,
Right.
then give them the courtesy of allowing,
Yeah.
allowing them to speak.
Absolutely.
Before us,
Yes.
I would go even further and say that that's required, it's mandatory.
Right.
If a representative of the property owner who's about to have a fine imposed against their property is here and wants to speak on that noncompliance affidavit, we are required by law, due process, to hear what they have to say.
Okay.
But if they're not here, and the only evidence you have is the affidavit, then our position is you can just accept that. Now, if you have questions and you want the city team to present the full story so that you all can be refreshed, we're happy to
Okay.
do that. I'm just suggesting we could move it.
And I agree. I mean, you started, for some reason, we started going into detail on some of these. Unless someone's here, I don't believe that you need to do that, because
That's good
the
advice.
case has been presented to you, you have your order, all you're doing is following up with something you previously had determined. This is a pro forma unless there's some comments by the city or the individual.
That's fine. You'll have to forgive my, I'm new at this job.
No, sir, it's something that actually.
Doing great.
I'm all for it.
No, this changed over time
did it?
with some of the
Okay.
boards, but we didn't
That's fine.
agree with that necessarily. It's just not something you need to do.
Understood. Well, I appreciate that. I'm sure everybody will appreciate getting out
Yes.
earlier by not having to go through this. So, moving on. Next, agenda item 5.7, case 1826, accept the affidavit of noncompliance for respondents Wolf Empire LLC at 1738 North Fort Harrison Avenue for permits. I'm
Yeah,
ready.
Go right ahead.
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states, if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second? Second. All in favor?
Aye.
All opposed? Motion carries. Item 5.8, case 3526 has been withdrawn. Next on our list, we have nuisance abatement lien filings. Case 92-25, accept the nuisance abatement lien for respondents Ibrahim Begovic, Edvina trustee at 1353 Lakeview Road for inoperative vehicle, and issue an order with a compliance deadline, and authorize the city to mitigate the violation if compliance is not met.
Good afternoon, Board.
This is going to be nuisance abatement at 1353 Lakeview. Dave Jensen, Code Inspector of the City of Clearwater. Case number is 92-25. It's going to be one violation, 31503B6 for an inoperative vehicle. These are the dates of the notice compliance. Return receipt has not been received back for the mail. This is the vehicle in question. There is no registration attached to the vehicle. There has not been since the inception of this case on 3/17. I did put a courtesy notice on the vehicle before posting it officially with no luck. Just the posting with the compliance date. On 4/3, after the compliance date, vehicle is still there, no registration on it. Close up the vehicle, no plate. This is Monday, vehicle's still there, no registration on it. Went by today and the vehicle's still there in the same condition with no license plate on it. Compliance can be met for the inoperative vehicle. Vehicle must display a current valid registration or be removed from the property. Asking for compliance 5 days after the board renders its order.
Board, do we have any questions? May I have a motion?
I don't have a question on this specific one, but is this another situation where do we need the presentation for this? If there's nobody here?
So these are actually an order that you're coming up with, so these are a little different. The other one is a follow-up to an order you already gave. So we like to at least have something put in the record in case we would have to defend this. So we do request at least a documentation, a minimum presentation.
And I provide the minimum.
Thank you for asking, and thank you for clarifying.
And thank you for
All
providing
right.
minimum.
We have no questions. May I have a motion, please?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Have a second. All right. All in favor?
Aye.
All opposed? Motion carries. Next case, agenda item 6.2, case 105-26, accept the nuisance abatement lien for respondents Lisa Upshur at 1610 North Madison Avenue for inoperative vehicle and issue an order with a compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon?
Afternoon, Board. Inspector Dixon, Code Compliance Inspector for the City of Clearwater. This is case 105-25 for 1610 North Madison Avenue. There's one violation at the property for an inoperable vehicle. Courtesy notice was sent out in March and with no change, so the notice was posted and mailed in April. There's a vehicle in the driveway. It's got flat tires, expired tag, and here's the posting. Today it still has flat tires and an expired tag. Compliance can be met by removing the vehicle from the property or make repairs so the vehicle is roadworthy, as well as display current license plates that's assigned to the vehicle. I'm requesting compliance 5 days after the board renders its order. I have spoke to them. Apparently it's an uncle's vehicle that's out of town, but no change.
Any questions from the board? May I have a motion, please?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry into the property to abate and maintain the nuisance and charge the respondent with the responsible cost, which will become a lien on the property. If cost, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Next case, item agenda 6.3, case 106-26, accept the nuisance abatement lien for respondents Jingbai Wang and Jing Tong at 200 Windward Island for lot clearing and issue an order with a compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Maddox?
Kevin Maddox, Code Compliance Inspector for City of Clearwater. Good afternoon. This is for 200 Windward Island, case number 10626. It's a nuisance violation, and at the end, you'll understand why it's not a nuisance abatement. In short, this is a large active beehive in the front wall of the garage door, which we do not abate. The code section is listed there showing that you can see that it's a nuisance based on furnishing of breeding of flies, mosquitoes, wood destroying insects, or otherwise threatens public health, safety, and welfare, which this does. Notice the violation was mailed and posted on 4/3, compliance date of 4/13. The green card was not received back. I have not received any information from the owner, a call, communication, or otherwise. This was called in by the neighbor who wanted to be here just to explain hearsay right now, but he told me, advised me that this has been going on for about 2 years. The house in front of you is from the street. In this area of the front is where this blown up area can be seen, and there's breaks throughout the wood and bees that I can see going in and out. I have a video 30 seconds long that I took yesterday if you'd like to see it. Otherwise, I attest that bees were moving in and out of this wall. This was on 4/3 of 2026 with the posting, and then 4/16. I'm always trying to take a picture with a bee in it, but if you'd like to see the video, I certainly have it. Compliance can be met for the nuisance beehive by using a registered beekeeper for live removal of the beehive, or a pest control operator for eradication of the beehive. With this recommendation for case 10626, 3-1503B5A, violation, large active beehive in the front wall of the house, requesting compliance on or before May 8th, 2026, or a fine of $50 per day per violation for each day the violation continues to exist.
I have a question for you, Inspector. Why a fine of $50 per day? I mean, we're used to seeing fines larger than that. If it's
Normally would ask for $150 a day. My compliance manager felt that at $50, and I agreed with her, $50 was just a more reasonable amount for this, but it could be 150, but 50 is what we recommended.
Is the dwelling occupied?
Currently, to my knowledge, from the neighbors, no.
So when you sent the notice that never got returned to you, you sent it to the address
The address.
that the bees are at?
No. We sent it to, I don't have it in front of me, but
Yeah.
the address that would be in property appraiser.
For the owner.
That's the legal requirement.
That notice goes to the,
Property appraiser's address that we have for the property.
Sometimes the address of the parcel is the address put in property appraiser. Sometimes it's in Tampa, New York, Chicago,
Sure.
somewhere else. We just legally use the address on file with property appraiser.
but you haven't, is there like a phone number that you can call the owner? And
We
let
don't
them
have
know?
access to phone numbers. Sometimes we find them in files from earlier if somebody happened to get a number. And we try and document that. We try and look back. No, I was not able to find a phone number or secure it.
Any other questions? I have a motion.
Well, is this a nuisance abatement?
No, it's a nuisance.
Declaration.
Just a nuisance.
Where is it?
BJ.
And
I won't be reading that.
This would be a nuisance handled through fines.
Right.
what you want to motivate the owner to take care of it rather than the city hire a beekeeper to go out?
I don't believe we currently have any abatement ability to use a beekeeper. It was something done in the past, but we don't have it any longer
That's
to our
complied
disposal.
prior to the meeting.
Oh, never mind then.
Okay.
We don't know which one.
I think we would just ask for your standard first and second
Yeah,
motions.
that's what I was asking.
But, oh,
We just go back to first violation on page 1.
wouldn't that be an unsafe building, though?
Would it be an unsafe building? No.
No, this is
It
just
would be more of a nuisance to the general
One at a
public.
time, please.
Page 1,
Thank you.
the other way.
I understand.
I move
I just had a
Are we ready
question.
for a motion?
Yeah.
Yes.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Have a second.
Second.
All in favor?
Aye.
All opposed? Motion carries. Have a second motion,
I
please.
move to enter an order requiring the respondent to correct the violations on or before May 8th. Is that what you're going with?
Yes.
May 8th, yes.
2026. If the respondent does not comply by that date, the board may order a fine of $50 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
And I have just a general question. Would you hire someone to remove the hive in this case, or exterminate? Just out of curiosity.
We would do neither.
I don't have a professional answer for that, but in listening to others who I've asked the question about, because this does not come up very often, we have in the past used a beekeeper who would come out and do it for free.
Oh, wow.
But in this case, I don't believe we have anybody to do that for us or that could be ordered to do it under an abatement process. But yes, it would be, as I was looking things up, it looked like it needed to be a professional beekeeper to take away the live bees. But in Florida, I did not find where it was illegal to use pesticides to kill them. It may not be the best way that we would like to have it done, but one way or the other, to get rid of the hive, they have those two options.
Thank you.
Thank you. Anything else from the board? If that's it? we
I
are-
just, go ahead.
You
Sorry.
didn't want to see my video?
I just wanted to ask, if they show up and there's like a bunch of liens on it, can they ask for a reduction? Is that something they can ask for? Okay. I just didn't know if that counted as a way to ask for a reduction.
If I get that buzz, I'll let you know.
Okay. And if you need a beekeeper, I got a number for
You
one.
got, okay.
Yeah, if you need one, I have one for you.
If there's nothing else, we are adjourned.
Thank you.
Thank you all.